understand that, Judge. This court has forced counsel upon me, and it is violation of Rule 1.16 and the Sixth Amendment. The
Okay, Mr. Handte, thank you. I understand your position. You're wrong. You're wrong. You're wrong in many different ways. You're also being disrespectful to the court.
I'll sit down.
Second Judicial District Court in the state of Nevada is now in session. The Honorable Barry Breslow presiding.
Thank you, Deputy. Good morning, everyone. Please be seated. Okay, we're on the record in the Hillygus Handte case. I'm here with the prosecutor, Mr. Silverberg, and the accused, Mr. Handte, Mr. Hillygus. Mr. Hillygus, it looks like you're a little bit chilly. Is it cold in here? I can turn the air conditioning off if you'd like, or for anybody's benefit, if it's too hot, let me know. Click on the air. If it's too cold, we can turn it off.
Turn it off, please.
All right, would you turn off the air? Push it all the way up there. Good. Thank you. All right. Couple things we're doing this morning. First is a reminder, Mr. Handte, please do not file any things on your own, even things you feel strongly about.
Judge, I would like to make a statement.
Hold on one second.
I would like to make a statement, sir.
All right. Please do not file anything, because right now you have counsel. I understand it's not a situation you want to be in, but the court has made a ruling that Mr. Silverberg remains your counsel. So
Sir.
Please do not file anything. I'm not going to hear from you right now. If there's a position you want to state, you have to do it through your attorney. Mr. Silverberg.
Thank you, Your Honor. So, Mr. Handte has indicated to me that he wishes to represent himself. I know at that last hearing, when he requested I file the motion for a young hearing, that was not clear whether he wanted to represent himself. I think that was something that concerned the court, because you weren't going to appoint another attorney and delay the trial. Now that he has made this request to represent himself, that was the document that he filed, I didn't file. I think he has.
You mean the so-called affidavit of truth, that document, or something else?
No, that document. And that was the document where he indicated he wants to...
So this would be a renewed request to represent himself, not to be confused with the first time he asked for the court's permission to represent himself. We had a hearing, I granted that request, and then later he asked the court to appoint counsel because he felt he was overmatched. Right. That's not the word he used, but that's the gist of it. So you're asking here on the Wednesday before trial, we're here to mark exhibits, we're here to for the court to pass out the redacted jury veneer and go over a few other housekeeping matters. He wants now to re-up his prior ask to represent himself.
Right.
Is that
so
right?
The prior ask, Your Honor, was for me to be taken off this case.
Right, and have somebody substituted for you.
Right. That's not his request now. His request is he wants to represent himself. I think that's a little bit different animal. I'm his attorney. I'm making that representation on his behalf.
Is that what you'd like the court to do, Mr. Handte?
Judge, under the Sixth Amendment, I'm allowed to represent myself.
Well, let's not talk about whether
okay,
no, hold on. Let's not talk about whether the court should exercise its discretion or make a finding. Is that what you want to do? You want to represent yourself?
Correct, sir.
Yes or no?
Yes.
All right. I'm not taking that up now. How come? I don't have time for this. It wasn't set for this. We're on the eve of trial. I have other things to do. However, I will take this matter up Monday morning at 8:45 a.m. I've already set a hearing on the motion to quash. We'll take this matter up first. And then if you end up representing yourself, we're going to go right into the motion to quash with you being self-represented. If the request is denied, we're going to go right into motion to quash. Mr. Silverberg remains your counsel.
Do you have a bond to sit on the bench, Judge?
Pardon me?
Do you have a bond to sit on the bench?
So that's enough, Mr. Handte. You can have a seat. 8:45 Monday morning, Mr. Handte.
I understand that, Judge. This court has forced counsel upon me, and it is violation of Rule 1.16 and the Sixth Amendment.
Okay, Mr. Handte, thank you. I understand your position. You're wrong. You're wrong. You're wrong in many different ways. You're also being disrespectful to the court.
Sit down. This is corruption.
You're being disrespectful to the court, Mr. Handte, and you're also trying to mess with the proceedings here. This is a Wednesday before the Monday trial. Now, I will give you a hearing. If there's good cause, I will consider it, but it's not going to be today. Mr. Silverberg, anything else on that issue?
Your Honor, I just know that I'm guessing the state would agree that a decision on Mr. Hante's position sooner rather than later.
It's sooner. I'm busy today, I'm busy tomorrow, and Friday, I've got commitments that take me out of the office.
Understood, just wanted to try to get that on sooner. Thank you, Your Honor.
All right, Mr. Stege.
I find myself in agreement with Mr. Silverberg. I don't think it's that. He's been through Florida canvas, I think, at least once, maybe twice. Renewing that today is a matter, it's a 5-minute matter. The difficulty is what we've seen here, sort of the disrespect as the court.
Well, I realize Mr. Handte has strong feelings about his role, the judicial role, constitutional rights. That's not lost on the court, and that's also informed by his years of service as a peace officer, which the court understands and respects his service. But, this is catching the court here when the court's taking the bench to talk about the jury veneer and marking exhibits and jury instructions and a few other things that are associated with selecting a fair and impartial jury. And if somebody's going to say here at the last minute that they want to represent themselves, I'll take it up. They have a right to be heard and the court to make an unbiased decision. They don't get to set the tempo though or direct when it's going to occur. I will do it as quickly as I can. The court, no surprise, I have other matters that I have to attend to. I've got a hearing this afternoon that I'm preparing for. I've got robust criminal justice docket tomorrow. I've got other matters that needs the court attention. So is this important? It is. Will I take it up in good faith? Of course. But I'm just not going to do it right now. So
Thank you.
End of discussion. Let's move on. Have a seat, Mr. Stege.
Thank you, Judge.
Mr. Hillygus, it looks like you want to be heard on this. Go ahead.
At this point in time, I'd like to preserve an objection for an appeal, and I'd like to do that. I'd like to make a record, and I'd like to be under oath.
Well, hold on. An appeal with respect to what?
To this hearing and to this case moving forward.
In light of the court denying the motion to continue the trial from yesterday, or for other reasons?
For other reasons.
Can you summarize for the court? I don't need to put you under oath. What is new that the court hasn't previously considered?
The clerk can put me under oath.
No.
I'd like to preserve an objection. I'd like to make a record for an appeal, and I'd like to do that under oath.
I'm not placing you under oath, Mr. Hillygus.
Okay.
This is, if you have a legal argument as to why the court should not proceed to trial Monday, please tell me what it is.
All right, so I'm going to do this. Everything that I say is the truth, the whole truth, and nothing but the truth, so help me God. This case should be dismissed for cause. Let the facts state that this case is based on false statements, lies, fraud, and perjury. I maintain my innocence, that no crime has been committed. I've been in these same clothes and socks and underwear for a week. I was only given new clothes this morning. No toothbrush for a week. I have to brush my teeth with my finger. The rules say that you must brush your teeth 2 times a day. I've been denied a shower last night and this morning. Before court today, the rules say that inmates must shower daily. I'm not able to shave completely or get a haircut for the last week or more. This is punitive and punishment. I've been denied phone use after court yesterday and all night, now for over 36 hours. And as a whistleblower, that's a violation of my rights. I've been denied tier time last night. I've been locked down now for 36 hours plus. This is punitive and punishment. I've been denied the message app on the tablet. It was removed by...
Hold on a second, let me hit the pause button, Mr. Hillygus. I'm looking for legal cause why this case should not go forward. Hold on.
It's coming.
Mr. Stege, you want to address the court?
Only that, as the court just stated with Mr. Handte, the court we have things to do this morning that have nothing to do with this. Perhaps we take up this at a later date, or at least once we get through the matters that we have.
Well, if Mr. Hillygus is coming to a summary here or a conclusion, then we'll move forward. If it's going to be longer than this, I have other matters we have to get to. Go ahead, sir.
What I was saying is the message app on the tablet was removed. That's a First Amendment violation. I was not able to send or receive messages after court yesterday. I've been denied my prescribed medical supplement, triple magnesium, for over 36 hours, 4 doses. I'm still not provided with a witness list by the DA, and that's a violation of the court rules, and there should be a show cause. I've not been allowed to access the laptop to view the thumb drive of more discovery, which is also a rules violation and a violation of the court order. I'm not provided with a new motion or a document filed by the DA. It's another rules violation. I've not provided an expert witness list, or excuse me, I've not provided an expert witness budget. That's a due process violation. I've not provided a table or a chair in my cell to access the court. That's also a due process violation. I've not been provided I have been provided a dilapidated wheelchair, and I'd like that to be brought out here so that the judge can see the condition of this dilapidated wheelchair. It's unsafe, it's a due process violation, it's an ADA violation, that's federal. I'm denied an ADA advocate or representative, that's a violation, that's federal. I'm being kept in solitary confinement with a light on 24 hours a day with a camera in the cell, that's punitive because I'm a whistleblower. I'm facing discrimination and retaliation for a DOJ complaint, and that's a civil rights violation, that's federal. No governor's warrant has been provided, which is a violation of the court order. Sanctions should be imposed. No extradition order has been provided or signed by a judge in Missouri, Los Angeles, California, or Reno. This was a warrantless arrest in LA. There's a Texas common law judgment, and that's a conflict of interest for this court to proceed. The DPS here in Nevada, Department of Public Safety, violated a subpoena. There should be sanctions and a show cause hearing. Multiple Fourth Amendment violations, illegal search and seizures by the Reno Police, the District Attorney, and this court. Felony perjury by RPD Detective Allison Jenkins in this case under oath. An FBI warrant has been concealed by the DA. That's a federal Brady disclosure violation. There's been a FOIA request which was 98% redacted, 220 pages, and that's been appealed. Still no ruling on a notice and demand to dismiss. That's a jurisdictional issue to move forward today. I am a state and federal whistleblower, and I have protections. I've asked for your oath and your bond, and you're in violation of NRS 282 and 266. For these facts and this testimony that I just provided as an affidavit of truth, this case must be dismissed with prejudice, and I must be released immediately. And I was threatened yesterday by Stege and 2 of his investigators. One of them is here right there. They threatened me that I'm going to be going to prison if I didn't take a plea agreement. I asked him to put the plea agreement in writing, and he refused.
Okay. Actually, let's start with Fry versus Missouri. Mr. Stege, have there been any offers to resolve this matter from the District Attorney's Office with respect to defendant Stewart Handte? And if so, what were they and how were they communicated?
During the time Mr. Handte had, I believe, his third lawyer, Mr. Pitaro, negotiations were at a gross misdemeanor offense. Those were communicated directly, face-to-face, to myself and Mr. Pitaro, who relayed to me that those were, he discussed the matter in great detail with Mr. Handte and were rejected. So that was likely...
So that's more than a year ago, right?
Oh,
maybe 2 years ago.
yes, yes.
Was that the only time an offer to resolve this matter was extended to Mr. Handte through his legal representative?
Yes, through a legal representative. Also, the court had invited the parties to consider a settlement conference.
Yes.
I expressed, that was when Mr. Handte was representing himself, I expressed to him my willingness to engage in that process, which he declined, or he remained silent, so I took it as a rejection.
Hold on.
And so, and other than that, with current counsel, only in the loosest terms of whether that would be possible, and so those communications have happened, but they've never gotten to any concrete or anticipated plea by either side.
All right, so just so I'm clear, there was an offer communicated through Mr. Pitaro to Mr. Handte to resolve was it all charges against him for a single plea to one gross misdemeanor or more than one?
A single gross misdemeanor count would have, and I estimate, of course I could be wrong, that was probably 2021 when that was occurring.
And Mr. Pitaro communicated back to you that that offer was rejected?
Yes.
Right.
And I will say, I've known Mr. Pitaro since I have been a lawyer in the state of Nevada and have a long working relationship with him. So
Well, you have no doubt that he's telling you what he recalls the truth to be.
he enjoys a reputation among myself and every lawyer I know as being among the highest quality lawyers.
All right, now if he were here now, I would look to him and say, Mr. Pitaro, did that occur? And presumably he would say yes, but he's not here. And so the next question then is, Mr. Silverberg, do you have any information one way or the other with respect to the comments from Mr. Stege that an offer was communicated at least a couple years ago through Mr. Pitaro to Mr. Handte to resolve these charges against him by having Mr. Handte plead to a single gross misdemeanor count?
So I'm not familiar with those discussions with Mr. Pitaro. I've had informal discussions with Mr. Stege about a gross misdemeanor, but in talking to my client in an attempt to formalize, he has said, don't pursue that, at least at this point.
Okay, well, I mean, this is the time I inquire as to, under 5 versus Missouri, if there's any offers and if they've been communicated. So, Mr. Handte, you're the only one here that, other than Mr. Stege, going back a couple of years, was an offer communicated to you, and you don't have to tell me why if you rejected it, I don't need to know the reasons, but I need to know if it happened. Was an offer extended to you to resolve these criminal matters against you by having you plead to a single gross misdemeanor count?
Judge, Mr. Stege, again, twists the truth. The truth is 2 offers were made to me, not face-to-face, while I was in jail through Mr. Pitaro. One was a gross misdemeanor, which I agree. The second one was a singular charge of a felony. We never got into the details of it. I rejected both. Also, Mr. Stege approached me outside in the hall when I was representing myself.
I'm sorry, can you slow down for me
Sure.
just a little bit?
Yeah, well, hold on.
Sorry.
That's right, we'll give it a slow down.
Sorry. I
So then, at the time you were representing yourself, you didn't have to go through an attorney, you went right
Well,
to
no,
you.
we had a conversation outside this court's hall, and he was strongly suggesting that I would take some sort of a plea, and he basically said, well, cops don't do well in prison. Again, to expound on what he said to Mr. Hillygus yesterday, this is a direct threat, or an indirect threat, however the court views it. But there were 3 offers, I believe, 2 through Mr. Pitaro, and 1, as Mr. Silverberg says, loosely given to him. I'm here to speak the truth. This man is not.
Well, I'm not attributing to him that he's intentionally misleading the court. The role here is to make sure that offers were communicated to you. And it sounds like at least twice they were.
Twice while I was in jail, correct. Through Mr. Pitaro.
One for a gross misdemeanor
And one
to
for
resolve all
singular-
the potential charges against you,
And
right?
one for a singular charge of a felony, but we never got into the details of it because I immediately rejected it.
All right, and you rejected the gross misdemeanor
Correct.
offer? And any discussions that have occurred lately have been, that there's been no formal or specific offer communicated.
You'd have to
Mr.
speak to
Silverberg, is that
Mr.
accurate?
So what we discussed is a no contest plea to a gross misdemeanor, time served. That's what I was discussing with Mr. Stege, but that conversation got cut short. I don't know if Mr. Handte still wants me to pursue that, but the last discussion was no, don't pursue it. So, Mr. Handte can speak to it.
The court is not allowed to get involved in settlement discussions in criminal justice matters, the presiding judge, and for good reason. There is no plausible reason why this court should or would or is lawfully allowed to interject itself. What the court is allowed to do is inquire what offers have been made just to make sure the defendant is aware that they have been offered and has made a decision and has been communicated back. I've just done that. The court is also allowed to recommend or suggest that the parties might want to go to a different judge to see if the matter can be resolved. I've done that previously, but that hasn't happened. No one has said, yes, we would like to do that. And I would set it up. I would find you a judge, and you would go see him or her and see what would come of it. The fact that there are some general but not firmed up discussions or possible negotiations at this stage, I really don't need to know any more about it. But if they're going to be had, trial's Monday, 9 o'clock, or as soon as we get done with other pretrial matters. So that's that. Let's go now to Mr. Hillygus. Mr. Hillygus, you had an attorney earlier, and then later on, the court allowed you to represent yourself. So Mr. Stege, what offers, if any, have been communicated to Mr. Hillygus to resolve this matter, please?
I have no recollection of ever making an offer through counsel to Mr. Hillygus. Yesterday, I, after court, asked Mr. Hillygus if he was interested in a negotiation. That conversation quickly devolved and was not fruitful.
All right, well, that's between you and Mr. Hillygus.
Yeah.
You understand Mr. Hillygus has a certain view of what was being said, but I'm not interested in that at this time. What I'm interested in is if offers were communicated either to him directly when he was self-represented or through his counsel when he had counsel. And your memory is there were none. Is that accurate?
My memory, yes, is that I don't think I ever made an offer through counsel to Mr. Hillygus. Yesterday, I was, willing to discuss, an offer that was probation eligible, given the serious nature and non-probationable nature of the charges, but sort of what we've observed throughout the case remained the case outside of court, and we were not able even to engage that.
Mr. Hillygus, was an offer ever communicated, even if Mr. Stege isn't recalling it, was one ever communicated to you through the attorney that represented you early on in this case?
Absolutely, there was a written offer that was provided, so he's false when he states he's.
Okay, well, either he's lying to the court or he doesn't remember.
A written offer.
Okay, and that went to your attorney and that attorney gave it to you?
I don't have it.
Okay, but did it happen that your attorney showed it to you at some point?
I remember there was a written offer, I may have seen it, I can't
Okay.
remember exactly what
All right, and did you reject the offer?
I don't remember what became of the offer. I know that there was a written offer, and
That's all you remember?
He has it in his files, it's a written offer.
Other than that, were there any other times that you recall the prosecutor making an offer to resolve this matter to you through your former attorney?
There was just the one written offer.
Understood. How about any offers made to you that were in a form that you could accept, as opposed to general discussion?
The only other one was yesterday, when I was being wheeled out by Sergeant, I believe, Sampson, that's here, that recorded the interaction. And I asked him if he recorded that, and he said he did.
Okay, but
I was threatened by Stege with prison time if I did not take this offer. He says, I asked him to please put it in writing, and he refused. And we went back and forth on that 3 or 4 times. And I said, go ahead and provide me a written offer, and I'll consider it. And he refused. He said, you're going to prison. You're not going to do well in prison. Or what? It's all recorded.
Okay.
That's a threat.
All right. So Fry versus Missouri, the court has now done what the law requires of it to inquire as to any offers that have been communicated. Different subject.
One other thing that I need to add.
Hold on. Mr. Hillygus, one moment.
The reason that an offer...
Mr. Hillygus, you need to stop talking, sir.
Okay.
Just give me a moment. I want to collect my thoughts here.
Actually, Judge, I have located here September 10th of 2020 a written offer.
All right, so Mr. Hillygus has remembered it accurately.
Oh, yes.
All right, what was the offer, please?
Plead guilty to counts of burglary and counts 4 and 5 of delivering simulated legal documents. I would agree to probation so long as he provided a written mental health evaluation from a licensed psychiatrist prior to sentencing.
And followed whatever recommendations might be. I mean, that's the idea, right?
Yeah, the idea is for the court and the parties to understand the full presentation of Mr. Hillygus in terms of crafting and appropriate conditions for probation.
Okay.
Now I can address what you.
Okay, so did you hear that? Does that refresh your memory that that was what the offer was? Plead guilty to one of the burglary count and two of the, false documents counts, and the state would not object to probation provided you had a mental health evaluation, and then people could argue about and discuss what the terms of your probation would look like.
So what I will say about an offer that was made, it's illegal because there's so much exculpatory evidence that's being withheld. And at that time, since then, there's 6,000 pages that have been dumped on me in the last 2 months. So how can you make an offer when you're knowing that there's all this evidence that's being withheld? That's an illegal offer. You cannot make an offer to somebody when you're not providing all the evidence up front that will exonerate this case. And I've said this many times before, and I'm very factual that they have and they know that there's so much evidence out there that proves that I have not committed a crime in this case. And so be able to make an offer without knowing that that evidence is being withheld and concealed and smothered is illegal.
Here's what we're going to do. I'm going to go off the bench for about 10 minutes. During the 10 minutes, I want you to think in your head, Mr. Hillygus, and Mr. Handte and Mr. Silverberg, I want you to discuss, please, and Mr. Stege, I want you to think in your head whether you would like this court to recommend to direct you to a settlement conference under Supreme Court Rule 252, I think, to another district judge tomorrow, or if I can't line one up tomorrow, Friday, to give it one more try to resolve this in lieu of having trial start Monday. Now, when I come back in 10 minutes, and I'll direct that the cameras go off, so that, and I'll make sure that the prosecution is in a different room so that free discussion can occur, not in his presence. When I come back, if the message from either side is a polite but firm, no thank you, then so be it. We move on. I don't hold grudges. It doesn't matter to me. I just want to give you the opportunity. On the other hand, if you say, yes, Judge, we'd like to take you up on that, see if you can make it happen. And I'll put things in motion to see if one of my colleagues is available on short notice to meet with you collaboratively, all together, one at a time, to see if you can resolve it. Either the entire case, or as just against Mr. Hillygus, or as just against Mr. Handte. But even if I come back in 10 minutes and you say, yes, we'd like to take you up on that, then I will put things in motion, but we still move forward. We still have things to do. Because even if you say, yes, we'd like to go to this settlement conference, you might not resolve it. You might try, but you just might not. So we need to get ready. But I want to give you a chance to think about that. Because I was unaware, as I should have been, I was unaware appropriately that what the negotiations had been, what the offer was, or offers. Not my business. It's my business to make sure if there were offers, they were communicated. There were offers, and they were. But I'm going to ask you if you want to give it another try. I'll be on in recess for about 10 minutes. TV goes off, or camera goes off, please. Mr. Stege will go to another office, another room. We'll see you in about 10 minutes after 10. Court's in recess.
All rise. All rise. This court is again in session.
Thank you. Please be seated. All right, we're back on the record. The media coverage may resume. Starting with the state, would the state be willing to participate in a Supreme Court Rule 252 settlement conference tomorrow or Friday, if the court could line it up with either or both defendants?
yes, conditionally. I'll say yes, unconditionally, but the idea of having the trial date still out there is very difficult.
Trials would not be postponed.
Well,
If I could,
I think I have support for this, only because an observation, and necessarily so, but we've been in court 3 mornings this week, and to set aside that amount of time with the trial date still looming, I reflect that there are a lot of balls currently in the air on this case, and time for myself to juggle those balls on the side as well.
Would be tough, right?
I mean, we're already, given the pressures are quite high at the moment, in discussion with Mr. Silverberg.
Well,
We're in the right neighborhood.
what would you have the court do? So let's suppose you said, yes, Judge, please direct us to a 252 conference, and let's suppose Mr. Silverberg, on behalf of his client, says, yes, they go in good faith. Would you, and then would you have the court move the trial date back a day to start Tuesday? Would you have it vacated and reset for within a month or two, or as soon as our calendar is allowed, which would certainly, I'm going to assume based on the argument Mr. Hillygus previously made that he needed more time in his current situation. He didn't want to go to trial Monday anyway. So
Right.
what do you think?
This is a course I would set for the court. I would refer us tomorrow to a colleague judge. Often the parties have a say in that. I don't know that would be the case here. I would vacate the trial date.
To be reset immediately after the settlement conference if needed?
Yes, because, and I will say, based on my conversation with Mr. Silverberg, who only as a messenger from Mr. Hillygus sort of expressed the desire to proceed with it, and expressed, so I think the parties are in the right neighborhood. The defendants are in sort of a resolution neighborhood that I think the state could probably get to. So, because
You have a level of optimism, is what I'm hearing, right?
which, yes, whether that's well placed or not, given what we've learned in this case, remains to be seen. But I express optimism to the court, so I would.
Okay, well, if I'm going to, and I'll hear from the defendants and Mr. Silverberg in a minute to see their view of this, but if the court goes in this direction, it gives the court a little breathing room to find you a settlement judge, because right now, if all parties want to do this, we send out an email in the next 6 minutes, and I try to find somebody for tomorrow or Friday, which, I can move mountains, but this is a particularly large one. On the other hand, if the message is, Judge, please set it up, and we're going to be postponing the trial, then I can offer to them next week, because I know you're all going to be available because we're supposed to be in trial. So we expand the calendar of available dates for one of my colleagues to handle this.
Yes.
You understand that? So that's a benefit.
I do, and I would also suggest that if we do that the parties remain today, because it may not take a judge to get us to the appropriate resolution. It might just take the parties.
Some more discussion time.
More discussion today, and if it is fruitful, the court might be able to act on negotiations in short order. So,
As in today on the record?
today on the record, tomorrow on the record, on the court's criminal calendar. I understand, the resistance, the state is, general resistance to vacating the trial date, difficult as it has been to get to this point, but based on all the issues presented, I believe it is in the best interest
Okay.
to do so.
All right, let me hear from Mr. Silverberg and then Mr. Hillygus. What do you think?
Well, Your Honor, Mr. Stege and I chuckle because we rarely are in agreement, as Your Honor knows, but I think we are in agreement on.
Well, you're both warriors, you're vigorous and professional and competent advocates for your respective sides. I respect that immensely. But here it sounds like there might be some common ground. So what is it?
So I share Mr. Stege's concern that, and one, let me just express my appreciation to the court for getting all these hearings right before court. The downside of it has been making it very difficult to prepare. I think that's what Mr. Stege is talking about with all the balls up in the air. There's a lot going on with this case, and finding the time to really sit and do that preparation work that has to happen right before trial has been a little bit difficult. I think that the parties are very close as far as a resolution goes. I don't think...
All parties or your client?
All parties.
Okay.
Is what has been conveyed to me anyway. I didn't relay any message to Mr. Stege that wasn't authorized by Mr. Hillygus. Again, I'm not his lawyer. I was just serving as a messenger to try to facilitate this process. So I think that we should vacate the trial date, give the breathing room to have this settlement conference. I think the breathing room is important because in order for it to be effective, it's not just showing up to the settlement judge and saying, well, we want this and they want that. I mean, I think that the parties are going to want to present at least something factually and legally to the settlement judge to assist. So I think that time would be helpful. And I think that not having the pressure of the trial date on Monday, given the fact that there is optimism, no guarantees, but there's optimism about resolution short of trial, save the taxpayers a lot of money. And I think it would be a good thing to do.
Okay, so Mr. Handte, I need to hear from your lips. Are you willing to participate in good faith in the Supreme Court Rule 252 Criminal Justice Settlement Conference?
Yes, Judge.
All right, thank you. Mr. Hillygus, are you willing to participate in and again, here's the approach. The approach is if you say yes, and I'm not twisting your arm to do it, it's your decision. But if the answer is yes, then a couple things happen. One, I move quickly to find a judge either for tomorrow, for Friday, or for next week. It's either a sitting district court judge or, per the rule, it can be a senior district court judge. They're also, by law, allowed to preside over these types of conferences. I'm optimistic I will be able to find somebody in these next 7 days, tomorrow, Friday, or next week time frame. So I would vacate the trial in order that it be reset if necessary to occur by the end of this year, right? I don't want to roll it into 2024. It needs to happen in relatively quick order. Two is I would reach out to my colleagues immediately to see who's available and willing to preside over this. And three, I would have you stay here for at least the next hour. And I would direct the sheriff not to transport Mr. Hillygus back, and I would make sure that the room's available. My next hearing here is 2 o'clock. So you could further these discussions. And if resolution is reached while I'm still here, and we have a court reporter, we go on the record, we memorialize what it is, and then things happen from that point forward. If that doesn't happen, no problem. The court will move it to a Supreme Court Rule 252 Criminal Justice Settlement Conference with one of my colleagues, either tomorrow, Friday, or next week. But again, I would vacate the trial. I would not pass out at this time the redacted veneer. I wouldn't explain, as I was going to do to Mr. Hillygus, how I'm going to let him use my board here for jury selection. But we don't have to go through that at this time because the trial is being vacated and will be reset if necessary. So, are we all in agreement?
I don't think yes, Mr. Hillygus.
And Mr. Hillygus, are you in favor of a Supreme Court settlement conference?
I'm going to look up that Supreme Court rule, but I want the court and everybody here to know I am a very reasonable person. I believe in everything that's been talked about here today, and I'm willing to go and figure out how we can get this resolved.
Good. I'll take that as he agrees. But the rule says that the presiding judge cannot force it, nor, if the parties agree, preside over it. Very good reasons for both of those. What I can do is suggest it and then find you a different district court judge or a senior district court judge, somebody who's retired but remains available to the court. So that's what I would do. Okay? I'll be in my office. In case I'm needed, at least through the 2 o'clock hearing. The court directs the sheriff to please allow Mr. Hillygus and the parties to be here at least for the next hour until 11:30. That's an artificial deadline, but at some point we need to use the court for other things.
Yes, and I would, before we take much more action, let's allow some of that more time between the parties, because that will really tell us.
Okay.
If optimism is well placed, so sort of belay all those orders just for a number of minutes. We can. I was not face to face with Mr. Hillygus. Get that.
So, Judge, don't vacate the trial right now.
Right.
Don't order a 252 settlement conference right now. Let's come back in a few minutes and
In a
make
few
sure.
minutes, and I expect we're all going to say yes, please do that.
Okay.
I
All right.
want to get face to face.
I'll come back in about 15 minutes. Court will be in recess.
All right, we'll let you know.
Okay, thank you. But again, no media coverage during the break time. Thank you.
All rise. This court is again in session.
Thank you. Please be seated. Okay, we're back on the record. Media is allowed to resume coverage. All right, who can summarize procedurally where we are? Why don't we start with Mr. Silverberg and then Mr. Stege, then Mr. Hillygus.
Thank you, Your Honor. I have consulted with Mr. Handte, my client, and I have served as some sort of a messenger person a little bit between Mr. Stege and Mr. Hillygus, and explained a few things to Mr. Hillygus. I think the parties are very close. We worked hard to try to do it today, but I think there are just some issues out there that
Well, we don't want to rush these things either, right?
Exactly. So I think we are in agreement for the settlement conference to take place hopefully sometime next week, that we vacate the trial date. If we're not successful, then we go forward and reset it as soon as possible. My understanding is that Mr. Hillygus is going to be requesting that the court appoint a public defender for the limited purpose of assisting him in the settlement conference, and if it's successful, doing the entry of plea and sentencing. If that's not successful, my understanding is he's going to want to represent himself. But I believe the parties on both sides are very close, and that the assistance of a settlement judge might just be what we need.
And next week as opposed to possibly tomorrow or Friday.
Yes.
All right, Mr. Stege, what do you think?
It was stated that there was reason for optimism. I think that reason for optimism remains.
So you confirm that the state is willing to go to a Rule 252 settlement conference, no objection to the court vacating the trial. In the event of a settlement conference next week that's unsuccessful, I'll probably then have a status conference and we'll reset it and other deadlines.
Yes, and as to timing, later this week or next week,
Whatever works.
I defer to the court. I think, speaking frankly, I think that time will be of more help than having a judge try to help us negotiate. But I think
As in more time?
no, I think just the time between now and the settlement conference will allow the parties to sort of get to their final bottom line. But I think it would be helpful to have a judge at that settlement conference. In speaking to Mr. Hillygus and in consultation with Mr. Silverberg, there's reason for optimism.
Okay. Mr. Hillygus, will you agree to a Supreme Court Rule 252 settlement conference? And would you like the court to appoint a Washington County Public Defender to assist you for the limited purpose of proceeding to that settlement conference, and if successful, to documenting the agreement and representing you at time of sentencing?
Everybody's been reasonable, and we are working together to resolve this, and that's something that I do request, to make sure that my rights are reserved, and if it's unsuccessful, then I will continue to represent myself. But,
Okay.
there has been a lot of reasonable minds coming together.
Well, that's good to hear. All right. So it's the order of the court as follows. Number one, trial is vacated. So as to that fact, this veneer that we had will not be used. I'm going to return all copies of the redacted veneer and the court's one copy unredacted back to the jury commissioner's office. So there will be no trial starting Monday. The court vacates the previously scheduled hearing on the motion to quash the subpoena recently served upon Debbie Hillygus. So that will be off. The court will defer at this time Mr. Hante's renewed request to represent himself, to be considered at a later time if needed. The court then directs the parties to a settlement conference in front of a different district court judge as soon as this court can set it up. I'm going to try for next week, but if one of my colleagues has availability this Friday, day after tomorrow, then I'm going to direct you there. Now, not tomorrow though. How come? Because I'm simultaneously appointing the Washoe County Public Defender to represent Mr. Hillygus' interests, realizing that it will take a little bit of time for that order to get to the Washoe County Public Defender, and for them then to assign somebody, maybe Mr. Prasad, who previously had been assisting Mr. Hillygus. He's shaking his head no. It sounds like he would prefer somebody else. In any event, the court will appoint somebody, but they need to be prepared to assist, and that's going to take some time.
And I will, of course, and I told Mr. Hillygus this, that I would
Collaborate
with whoever that is.
All right, so that makes it look like this settlement conference is not going to happen until next week at the earliest. So realistically, excuse me. Realistically, Friday of this week would be too optimistic. So somebody gets appointed this week. Mr. Silverberg, please, with the court's encouragement, reach out to your colleagues over there, find out who that person is going to be, and then let them know the judge wants this matter heard next week in a settlement conference. And once I know what date that was set for, we'll set a status hearing to see where things stand. Okay? In the event the parties try in good faith and do not resolve it, we will reset this case for trial just as soon as we can get it done. Court prefers by the end of this calendar year. If the parties are able to reach a resolution, it needs to be reduced to writing in the form of a guilty plea memorandum, gone over and signed. And then the court would entertain a change of plea, and then we'd go from there. Any questions from the state at this point?
No.
Anything else, Mr. Silverberg?
No, Your Honor.
Anything else, Mr. Hillygus?
There is one thing.
Go ahead.
If I can be taken out of the infirmary and put back into a regular cell with someone else because I'm being isolated in solitary.
So let's do this. I'm not going to order that because I don't impose the court's directive on those types of decisions. But let's do this. Yesterday, I think I asked you if you wanted the court to appoint you someone for medical issues, and you politely but firmly said no thanks. But if I'm going to appoint someone to represent your interest for the settlement conference, does it not make sense for the court to also give them authority to work with you on medical related issues like this? In other words, if you want an advocate to go to the sheriff and say, I want my guy to be classified differently, then, you know, rather than just your voice alone, maybe somebody can be your champion there. How does that sound?
I'll just stick with the original person that's going to work on this agreement.
So no thank you again.
If they want to do something there, back there, they can do that. They have that authority. I'll leave that up to them. Maybe they can somebody can refer that they do something like that.
Okay.
And I recall the doctor who testified by Zoom seemed willing to work with you and your advocate right away to discuss your.
Okay, then I'll limit the appointment for purposes of assisting Mr. Hillygus with the upcoming settlement conference and any follow-up in the event that it is successful. All right, thank you everyone for your hard work today. The court will be in recess. Have a good afternoon.
All rise.